California's gun ban still in effect after the Ninth Circuit Court of Appeals has issued a stay on a lower court's ruling, while you've also got action happening in the Southern District of Illinois against Illinois' gun and magazine ban. A date being changed there for the state to respond. Welcome in, Bishop on Air. Happy Monday, and a lot to get to today. We'll obviously tackle the latest in gun ban litigation, where you've got the California Ninth Circuit Court of Appeals issuing a decision over the weekend to put a stay on the lower court judge's opinion, saying that California's ban on semi-automatic firearms is unconstitutional. Now, that original order from the Southern District of California court, that happened, 10 days ago. We talked about it here with Alan Gottlieb, the founder of the Second Amendment Foundation, ultimately what happened there, and just a flashback to that conversation we had with Alan last week, and what it ultimately meant moving forward, especially for Illinois' gun and magazine ban case that's making its way through the appeals court as well. So again, here's Alan Gottlieb flashing back to our conversation a bit from last week.
What's interesting is that this case has already been there once before. We won this with the same judge a few years ago. It went up to the appeals court, and it then went all the way up to the bank appeals court, which then, after the Bruin ruling, where the Supreme Court, said that you have to go by the text of the Second Amendment and the history, not by any, social science or, balancing act test, the court remanded it back down to the court to review it in light of the Supreme Court ruling, and came up with a stronger ruling in our favor, and now it's going to go back up through the process. Eventually, it's going to go to the U.S. Supreme Court. It may not be the first assault and ban case to actually get there. The Second Amendment Foundation has previous cases filed in Illinois and Maryland that might get there first. But the Supreme Court is definitely going to be hearing this case, and eventually California citizens will get relief and be able to own semi-automatic firearms that the state likes to call assault weapons.
So, again, you've got Gottlieb laying out there some of the arguments that the state has been making, talking about balancing public interests with rights, which the Bruin decision from last summer, not this past summer, but the summer of 2022, said cannot be considered when dealing with constitutional rights like the Second Amendment. But Gottlieb, with a little bit more from last week, here's what he had to say about the trajectory moving forward.
Yeah, there are 8 or 9 states that have these kinds of laws on the books right now. California, Oregon, Washington, Illinois, Maryland, New York, New Jersey, Massachusetts. And so it's going to impact us. It's going to take time. And like I tell gun owners and gun rights supporters, you got to be a little patient. The court system just doesn't work that quickly overnight. Eventually, we are going to win this case. It's going to go to the U.S. Supreme Court, and the so-called assault and bans of commonly owned firearms that are not dangerous and unusual, those laws are going to get struck down, and people are going to be able to continue to own those firearms.
So over the weekend, you had the Ninth Circuit Court of Appeals issue a stay on Judge Benitez's initial ruling that California's ban on certain semi-automatic firearms is unconstitutional. I'm just going to look here at the docket. It says that in light of this court's published order granting a stay in Duncan v. Bonta, which is the California magazine ban case. In that case, you've got the question of our magazines to be, and my cat is the joys of broadcasting from home. Got a cat here that's all up in my business. But you've got the Bonta case, which is the magazine ban, that the Ninth Circuit Court of Appeals put a stay on after Judge Benitez ruled that the magazine ban's unconstitutional. So the court says, in light of that published ruling, concluding that the Attorney General of California is likely to succeed on the merits of that case, and they said, in similarities between Duncan and this case, we grant appellant's motion for an administrative stay on the district court's October 19th permanent injunction, because it is a permanent injunction, and judgment. And granting an administrative stay, we do not intend to constrain the merits panel's consideration of the merits of the appeal in any way. The administrative stay shall remain in effect until the merits panel decides the appeal on issues and order lifting that stay. So there's still action that can be happen in the Ninth Circuit Court of Appeals with the stay on the state of California's gun and magazine bans. But you did have a dissenting judge dissenting against that stay order in California, saying that they would deny the appellant's motion for a stay pending appeal, saying this judge in particular, Callahan, out of the Ninth Circuit, said, "I do not believe that we are bound by the published order in Duncan v. Bonta, and I do not believe that appellants have otherwise met their burden of showing a likelihood of success on the merits, and that they will suffer irreparable harm and injury absent a stay." So interesting to see some of the back and forth there from the courts. That's California, right? Dealing with California's semi-automatic ban and magazine ban. But if you look at Illinois, there was even action last week when it comes to the plaintiffs' federal firearms licensees of Illinois, asking the Southern District of Illinois to reconsider and to have an amendment, rather, of their complaint to try to halt Illinois' gun registry. So this is back in the Southern District, while the Second Amendment case is being deliberated by the Seventh Circuit Court of Appeals in Illinois, challenging Illinois' gun and magazine ban. You've got the federal firearms licensees of Illinois asking the Southern District judge, who already issued a preliminary injunction in this case, to allow for an amended complaint to try to halt the gun registry. That opened October 1st, and here we are at the end of October, and at least the first 3 full weeks of gun registration data, it only shows 0.08% of firearms owner identification card holders in Illinois registering and disclaiming that they have a banned firearm. So last week we had the Southern District of Illinois federal court say that they have to, the state has to respond to a motion to appeal, rather not a motion to appeal, to amend the Southern District case, and they were given a November 6th deadline from Judge McGlynn for the states to respond to that amendment motion. But then over the weekend on Friday, you had McGlynn scratch that date. So it's not November 6th now. It's now November 1st. So we actually, 5 days earlier than anticipated, the state's going to have to respond to the federal firearms licensees of Illinois' request to amend their complaint. So that's another update here when it comes to the issue of how exactly we're going to see this play out back in the Southern District when it comes to the question of, are we going to have the registry move forward with that January 1st deadline to register firearms, or face a possible Class A misdemeanor or a Class 3 felony for second and subsequent offenses? The federal firearms licensees of Illinois asking for that to be postponed or shot down entirely. But you still got Thomas Magg's case lingering as well, where you've got him saying that it's too vague to enforce, and Judge Stephen McGlynn considering that also. So a lot of movement over the weekend, not just in California, but also in Illinois, where the deadline for the state to respond to that motion to amend their complaints from the federal firearms licensees of Illinois, moving the deadline from November 6th to November 1st. So we've got, 2 days the state has to now respond to the motion for an amendment there. I talked with State Senator Jason Plummer before legislators left for the first week of fall veto session on Thursday, and he's got that measure that would hold harmless individuals who purchased firearms during that 6-day window that Judge Stephen McGlynn issued a preliminary injunction in Illinois against the state's gun and magazine ban, and people went out and bought firearms during that court-ordered injunction. They were following the law. The court enjoined the state, and these individuals went out and purchased firearms. But state police say that they cannot legally register those firearms after January 1st, 2024, because they were obtained after January 10th, 2023, when the state's gun and magazine ban went into effect. So Jason Plummer, he wants to essentially change state law to allow those individuals to register those firearms if indeed the courts uphold Illinois' gun and magazine ban. Here's Jason Plummer.
Well, obviously, the folks on my side of the aisle love the concept. It's very common sense. It shouldn't matter where you stand on the Second Amendment issue. This is just common sense legislation. Unfortunately, right now we're not getting a lot of traction with the other side, but there's still time to go before January 1st.
So still time to go before January 1st. Jason Plummer hopes that the final 3 days of fall veto session, they could possibly deal with this. But clearly there's a lot of back and forth as to how exactly to deal with violent crime and the different perspectives there are. Plummer, he lays out that indeed he thinks that this law is unconstitutional and is looking for some changes to how the state goes about dealing with violent crime.
Well, obviously we all are waiting for the courts. I think a lot of people, including myself, feel strongly that the legislation has a lot of weaknesses. It's unconstitutional. I think ultimately the courts will rule that. So why the governor, why the attorney general, why their legislative allies are putting law-abiding Illinois gun owners through this circus is just frustrating to me. Instead of pushing extreme legislation, why don't we address the issues at hand? They don't seem willing to do that because every issue is a partisan issue, and really every issue should be public policy driven, and there's ways to solve some of the problems that everyone wants to see addressed.
And final comment from Senator Plummer when I chatted with him on Thursday.
Compliance rates less than 1/10 of 1%, and they're going to have a tremendous amount of problem with compliance, and frankly all those law-abiding gun owners, I firmly believe what they're doing is right. There shouldn't be a registry. This legislation is unconstitutional. The courts will eventually rule that. The governor and the attorney general need to quit pushing such extreme stuff. They need to fall into line.
So there you've got some of the latest status updates on not just Illinois' gun magazine, but California's gun ban and where exactly these things are in the court system in different jurisdictions. But over the weekend, you've got other instances of mass shootings, including down in Florida and in Chicago. And coming back, we'll delve into that latest mass shooting in Chicago with hearing what police had to say in the news conference yesterday, and some of the statements from Chicago Mayor Brandon Johnson and how exactly other elected officials look at possibly dealing with violent crime of this sort, including Governor J.B. Pritzker talking about mental health and more. Stay tuned. We'll get to that coming up here. It's Bishop on Air. Like, subscribe, hit that notification bell so you can stay up to date daily with what's going on with Illinois' gun and magazine ban and what's happening elsewhere throughout the country when it comes to the Second Amendment. So stay tuned. Plenty more to come. Hey!